So I think the starting point is to discuss the provisions of the Children's Act and more pertinently, what is the legislative mandate in respect of the court and the role players who approach the court in respect of matters pertaining to minor children. In that regard, a Form 2 is an application form wherein a party, normally a parent, would approach the court if there is a dispute in respect of care or contact. Sometimes if there is a dispute in respect of schooling of the child or relocation of a child from a certain province in South Africa to another province in South Africa. But Form 2 is there for the general public. When it comes to a Form 36 is a document which mandates a court. Well, actually, a Form 36 is premised on a court order, which is to be granted by a magistrate of the Children's Court, which would enable a social worker with the assistance of the police to remove a child who has been found to be in need of care and protection. There is indeed a constitutional court judgment in respect of the removal of children, and a Form 36 deals with the removal of children who are found to be in need of care and protection in accordance with the legislative section 150 of the Children's Act, Act 38 of 2008. Now in that regard, the Children's Act specifically legislates who is a child in need of care and protection. The grounds are listed in the legislation being the Children's Act, and the purpose of the removal is to remove a child who is either being neglected, abandoned, or is in a toxic, hostile environment which is to the direct detriment of the minor child. Now, the issue in respect of the Constitutional Court judgment, and that's the matter of C versus a Minister of the Department of Gauteng Social Welfare. What the pre-Constitutional Court judgment position is that a social worker, without having to approach the court, could remove children if they were of the view that the child was in need of care and protection. Furthermore, the provisions of section 150 through to section 154 deal with the process in respect of removals and the subsequent appearance at the Children's Court. The crux of the Constitutional Court's judgment is that to remove a child is an extremely invasive process wherein the state is now meddling with private and family affairs. There needs to be substantial cause and reason for a social worker to remove a child from their home environment. This must be seen in accordance with section 28 subsection 1 of the Constitution of South Africa, which states that a child has the constitutional right to parental and or family care. Only if parental and family care cannot be provided in the best interest of a minor child by the family, and that the child is being severely neglected, abandoned, the child's been orphaned, the child is addicted to substances, should a child be removed. In the absence of severe neglect, abandonment, or abuse, a child is not to be removed, because removing a child is a contravention of section 28 subsection 1 of the Constitution. However, when it is found by a social worker that there is a basis for a child to be removed, the social worker now must approach the court. The social worker cannot in the absence of approaching the court and obtaining an order from the Children's Court's magistrate, remove a child. The pre-Constitutional Court judgment position was they could. The Constitutional Court's judgment says that they cannot do so, and that they must first approach the court. The second point in respect of the judgment, which was penned in 2012 by the Constitutional Court, is that in terms of the legislator, a parent had to wait 90 days before they could approach court in order to challenge the decision to remove the child from the family environment. However, the Constitutional Court's judgment states that the provisions of Section 152, I believe it is, I must just have a look at that, the precise section, is unconstitutional insofar as it infringes upon a parent's right to be heard in court, and that the Children's Act was amended by the judgment by reading in to state that after the removal, the parent has the direct right and must be brought to court within 48 hours from date of the removal. Of course, when we speak of hours or days in respect of a court spectrum, we talk of court days. So if a child is removed on a Saturday, the child wouldn't be brought to court on the Monday. The child and the parents will be brought to court on the Tuesday. Now, the purpose of bringing the parents and the child to court, and this is something which from my experience I've seen is not done either properly and sometimes at all, is to allow the child and the parents to vocalize their views in respect of the removal, and for the parents to challenge the validity of the removal. The reason that a matter must be brought to the Children's Court on 48 hours written notice to both parents is in order that both parents are entitled to the right to automatically review the decision to remove the child from the family environment.